SJC 11972, Commonwealth v. Jamal R. Oliveira, and SJC 11973, Commonwealth v. Mitchell T. Violet.
Good morning still.
Good morning, Your Honors. Mr. Chief Justice and members of the panel, I am Yulmi Cho for the Commonwealth. Impoundment is an appropriate course of action when the owner or the manager of the parking facility requests the car to be removed.
Isn't this the Dartmouth Mall?
Yes, Your Honor.
So the manager of Kohl's is the owner or manager of the parking lot?
Oh, I apologize. Kohl's department is a separate department store that's across the street from Dartmouth Mall. So it seems that the parking lot that the manager was speaking about was part of the Kohl's parking lot, but it was perhaps shared or could be used by other customers who were also in that strip mall. But I think there's no further record established regarding this, but
So we don't really know that this man whom was spoken to had in fact authority over who got to park in that lot or not.
I think there's enough evidence on the record to say that the manager could speak for the parking lot. When he testified, I think it was Jason Strabella, testified about his experience working for the store for 8.5 years and that he had been the manager there for 4 years. And while the loss prevention officers were interacting with the officers, when the situation escalated a little further, the officer retrieved the manager. And I think the manager then additionally, during the manager's introduction, he testified that he speaks for the operations of the store as well as the safety plan, as well as other sort of operational plans of the store. So I think
But only about the store, not about the parking lot, which there's no suggestion Kohl's owns or controls.
Not directly, Your Honor, but if the LP, the loss prevention officer, and the manager takes it upon themselves to speak for the store regarding the parking lot, I think that's an inference.
But am I correct that the inventory search was done before the Cole person said, "I want it removed"?
No, Your Honor.
I thought
That's what he testified.
Your brother says he didn't want the car with the gun in it, and the gun was found only during the course of the inventory search. So would that not suggest that this occurred after the search was already done?
That was the testimony of the loss prevention officer and the testimony of the store manager. But that was contradicted by the testimony of the officer who was testifying for the Dartmouth.
Didn't the store manager testify that he was told there was a car there with a gun in it?
Yes.
Well, you could only know there was a gun in it if he wouldn't have known that if that search hadn't happened.
Correct. So what happened in this case is that there's a contradiction between what the Dartmouth police officer said, which was that the representation made to the manager was only that the car may remain on the lot overnight. Then the manager said, "I would like the car to not remain on the lot overnight." Then the search took place. Then the firearm was found. So that was the testimony of the officer. Then the manager and the LP officer said that their testimony was that they were told that the firearm was there already, and because of that, they wanted the car removed. So there was a contradiction.
Which did the judge say?
So this credibility conflict was decided by the motion judge, which was that the decision, the manager first said, remove the car, then the search took place, then the firearm was found.
It's not quite so clear. I mean, I read her decision as sort of a little confused on that. I mean, just not very definitive on that point.
I think she was not definitive about the timing of when the bullet was, the 9mm round was found on Mr. Oliveira. So her decision regarding that, which was not related to the inventory search, that was, she was not, she didn't make a finding on that, but I think in terms of the credibility of how the search transpired, I think she made a very distinct, very clear finding on that. I think that issue was, the credibility issue was actually flagged for the judge. At the end of the defendant's testimony, the defense witness's testimony, the ADA at the motion flagged this issue directly for the judge by saying, had I known that there was going to be defense witnesses contradicting this particular, this piece of information, I would have not started the hearing until the second officer, who had not been available on that day, summoned but not available that day because he was out of the country, rather that the ADA would have asked for a continuance. So at that point, the ADA said, because of this conflict in testimony, which is on very critical piece of information, the ADA asked the judge to suspend the motion, the hearing, until the second officer could come in and testify regarding what actually happened, to boost the credibility of the officer who testified for the Commonwealth. The judge at that point was flagged as to the conflict on the credibility, and I think then you go on to look at the written finding of the judge, which lists out that order, that the manager was told that the car may remain on the lot, and then the officer, then after that, took the inventory, and then after that, the firearm was found.
So is it your view that whenever the owner is not there, that the Commonwealth is entitled to do an inventory search?
No, Your Honor.
So what, but I mean, what then about these circumstances are sufficiently, would justify an inventory search? I mean, this is a case in which the person was not even facing imprisonment, I gather. Do you agree with that? The shoplifting charge doesn't have any time attached to it, just a fine?
So answering the imprisonment, no, Your Honor, I wouldn't expect a person to be imprisoned for.
Not expect to. I mean, I
right,
gather,
no.
according to your, I've not gone back to the statute, but your brother writes that the shoplifting statute has a maximum of a fine.
Yes,
This was a
So
first offense, right?
yes. It's
person
not,
was not, the person at the time that the inventory search was done was about to be arrested for a crime that did not include the possibility of any incarceration, and therefore you would think would be a very, very strong candidate to be released on bail.
I think that would depend on the person's criminal history, or, you know, whether the person was on probation at that time or anything like that. So there is, and given that this arrest was happening at 4:30, and the district courts usually close around 5, I don't think there was a guarantee that the defendant would be back later that evening to retrieve the car. Regarding the registered owner of the car, the defendant's wish was to have her come and retrieve the car. So, but the defendant didn't make a representation regarding the registered owner's availability or ability to retrieve the car. So we don't have a case where the officer is presented with a practical and prompt alternative to impoundment. Thus,
Well, I mean, it's 4 o'clock in the afternoon. It's not likely he's going to be held, right?
it's possible that he may be held overnight
Why?
to be arraigned in the
But
morning.
I mean, first offense for something that's a fine, it's highly unlikely.
And what happens on a second offense?
I think it's not necessarily regarding the nature of this offense, but I think the question of bail considers the likelihood of the defendant appearing for court.
Never been charged with anything before.
I don't know if the BOP's in the record. I reviewed it yesterday, and I don't necessarily know that he would have been
Well,
released overnight.
I mean, it's a public parking lot. It's not. There's no indication of safety issues. It's very hard to see why at 4 o'clock in the afternoon, given the offense, given that there's a girlfriend who might come.
I think that piece, the girlfriend might come. I think
Given
that's
the
the
offense,
issue.
and it's not a threat. It's not on the side of the road. It's
Right.
not a high crime area.
Right.
No
So-
threat of vandalism.
Right, so those aspects are not present in this case, but I think on what the officer knew and didn't know, which is the availability of the girlfriend to retrieve the car.
But
It
it could
was-
have been made, one simple call could have settled that. And it's unreasonable, it seems to me, to say you can't even make a call to try to figure that out.
This court has not decided whether the officer should consider the prompt, reasonable alternative to to impounding the car. Thus, I take that to mean that the officer never had the obligation to investigate whether what the defendant wanted to do was prompt and
How
reasonable
about just
alternative.
the obligation to be reasonable?
If the obligation was never on the officer to make that inquiry, and we don't know if the call would have led to a prompt and reasonable alternative to impoundment, I think it's reasonable for the officer to not have made that call, but rather consult with someone who's on the property, the store manager who had been engaged with the process all along, to ask that person, would it be okay? I don't know, he can't make any representation about the girlfriend or the defendant, but if the car was to remain overnight, would that be okay? And the manager spoke for the propriety interest of that parking lot, and I think following that was reasonable in this case.
Was there ever,
But where the choice was put to the manager of the store, why were the police even involved at that point afterwards anyway? If the manager didn't want the car there, why wouldn't the manager of the store have the obligation to call a towing company and have it removed?
He doesn't.
Well, why do the police have, why is it their business?
I think it's this court has recognized the police honoring the propriety interest of the
but he isn't the
party.
proprietor.
I think this court was quoting Professor Lefebvre's treatise on search and seizure when it stated in Commonwealth versus Brinson that impoundment is appropriate when the owner or the manager of the store could speak for the parking facility. Kohl's department store, I assume, is a corporation, and it is impossible to detect exactly what the corporation's interest is. That is why we have the store manager to speak for the store's interest based on the guidelines put forth to him by the store, which he was following, and which I presume he was following, and he represented on the record during his testimony that he speaks for the, in larger.
For the store. He speaks for the store, is what he said, isn't it?
Yes, but I would assume that a parking facility used by customers going into Kohl's would be a part of Kohl's department store.
So
The joint parking, didn't you say it's a strip mall?
I believe so. It's definitely not part of the Dartmouth Mall, the larger mall. It's across the street.
But it's also not, it's not
Standalone,
private
no.
property. Okay. Can I ask you a separate question?
Yes, Your Honor.
I take it Mr. Violet gave permission to go get or to go get whatever it was in the car, or to enter the car. Was an argument ever made that there was a consent to search, or was the fact that nobody went into in other words, nobody went into the glove compartment at the time that the bag was brought out?
Wasn't it specific to the bag, the consent?
Yes. So
Okay, that's what I wasn't sure.
we did not argue, nor
Right,
do we
because it
argue
was
now that.
specific, you can get the bag, we've paid for the stuff.
Yes.
Yeah.
So that
Okay,
consent did not.
the
reach out
consent
to-
was limited to that. I wasn't clear about that.
Yes. Okay. Let me see.
So let me actually, if he had been the owner of the car, and the Kohl's person says, "I want you to tow it," that would be enough? Even though the owner may have said, "No, I want you to leave it there. I'll deal with it."
This is the owner of the car saying it?
Yeah, and it was that Violet owned the car, it wasn't his girlfriend's.
If that had been permissible with the Kohl's manager, I think under that circumstance, it would have been reasonable. The reasonable thing to do for the officer would have been to leave the car there,
Okay, well,
yes.
but in my example, the Kohl's owner says, "Get rid of it. I don't want it here."
Right.
It would still be enough to tow?
I think under Brinson, yes.
Okay, and is the inventory policy part of the record in this case? Was it filed as part of the record?
I think the findings made by the judge, I think quotes from the inventory policy. I think the inventory policy itself is possibly missing from the record. I tried to look for it in the clerk's file.
Specifically found it was a perfectly valid inventory that was done.
Yes,
The issue is whether the impoundment was valid.
yes, Your Honor. I think the impoundment itself was in compliance with the impoundment policy of the department also, which I think is a factor towards the Commonwealth's argument, since it's indication that the officer was not acting arbitrarily.
And is that policy part of the record?
Just the part that, yes, Your Honor. So it was admitted into evidence during the,
So there is an impoundment policy that was an exhibit that was admitted at the hearing?
yes, except it just happens to be missing from the clerk's file, so I could not attach it to the brief, unfortunately.
Does anybody have it?
All my efforts to track it down,
The police don't have it anymore? They don't have the same policy?
I have a copy of what they use now, but somehow that particular piece that was entered into evidence, that I couldn't track down, even though I tried fairly.
So that was an exhibit that's lost now?
I believe so.
Well,
Okay, thank you.
Thank you.
Still, good morning, Mr. Levin. Before you get started, this missing policy, do you agree that it was offered as an exhibit at the hearing and that it's just missing?
I think the transcript seems to indicate that it was entered as an exhibit at the hearing. I didn't really make any effort to track it down, to be honest. I don't think it's really relevant to the issues on appeal.
I think her decision actually, somebody quotes what it says, and I think.
Yes, it's at page 24 of the record in the judge's decision. She notes that the police tow policy permits them to forego inventory and impoundment if the car is legally parked unlocked.
Okay, and you don't have any reason to question that that's what it says?
I'm sure that's what it says, Your Honor.
Okay.
So do you also agree that where the store manager asked to have the car towed, that the police had the authority to tow it?
Absolutely not. There's no support in the record for that suggestion. This is a public parking lot.
But legally, if a private individual asks to have the car towed, do the police
I mean, the store manager is in no different position as to that public parking lot than I am.
So if you were to
public
complain
parking
about-
lot, meaning it's owned by
The
the town?
only testimony in the record on this, the police officer testifies on direct examination that this parking lot is technically a public way, that it's shared by multiple businesses. On cross, he testifies that he's not aware of any time that it closes.
Yeah, but it's public in the sense that it's an area to which the public has a right of access, but it's still private property.
I don't know the answer to that, Your Honor. It's not in the record. The only thing in the record is that it's technically a public way.
Well, public way means, doesn't it mean that the town owns it?
That's certainly the suggestion that's given by the police officer
So
in
if
his
the
direct
town
testimony.
owns it, aren't you in a worse position?
No.
I don't think so. I mean, the store manager, if
Store
I go to
manager
visit my
doesn't have
friend's
anything
house,
to do with it if it's a public way, does he?
well, no, that's part of my argument, Your Honor, is that there's no reason to think that the store manager has any authority whatsoever over this public parking lot.
So.
And this, I want to be clear, this isn't a case where the police pull over a vehicle and arrest the driver and then have to figure out what to do with the car. This is a case where the police arrest a person who happens to own a car, go find the car and tow it away. This is like if I was visiting my friend in Jamaica Plain and I park down the street and I get arrested on a warrant while I'm at my friend's house and my friend says, oh, also tow the car away from down the street, I don't want it on my street.
So the manager's statement to have the car tow away, it's equally consistent with, well, yeah, it's a public parking lot, but it's taken up the space that a customer might use to come into our store. I would love to have it taken away.
I mean, that is not what he meant based on the testimony in the record. He didn't want the car in the parking lot because it had a gun in it.
Can I ask you about that question? I think that it's just not clear what she found on that point.
Well,
So, but I understand, I didn't realize this before, that there was actually a discussion about that and a holding. So maybe we are supposed to read this, that she found that the search was after he had, if it's relevant at all, that the search was after the store manager had asked that the car be towed.
Judge Hand made no finding about the sequence of those events. She found that the police did not know that either defendant had a bullet in his possession until after they found the gun. That's the only finding in terms of the sequence of events.
Okay.
And there is no testimony from any witness at the hearing about any conversation with the store manager when police did not know about the bullet. The officer's testimony about that conversation,
But I
quoting
thought
from-
that the conversation about the gun, that there was a witness who said that the conversation about the car with the store manager preceded finding the,
no witness said that. The testimony.
the police officer didn't say
The
that?
testimony gives rise to that implication because of the orders in which the questions were asked. The prosecutor asks about the conversation with the store manager before asking about the inventory search, but the police officer doesn't explicitly testify, I spoke with the store manager first and then went and conducted the inventory search. I'm reading from page 20 and 21 of the transcript. This is the only testimony about this conversation that comes from the Commonwealth's witness. He says, I was present for that. Officer Canuel spoke with the manager of Kohl's that night, informed him that these two gentlemen were going to be arrested for the shoplifting and for possession of the ammunition, and that the vehicle will be left overnight, possibly in the parking lot. And he stated to us that he would like it towed and removed from the property. Now, this is the Commonwealth's only evidence about this conversation, and it clearly states that they already knew about the ammunition before the conversation took place. So my argument is that the judge's finding that they didn't know about the gun until after they found the bullet implicitly subsumes a finding that this conversation also took place after they found the gun, because there's no evidence from any source in the record on which she could rest an alternate finding.
Okay.
I mean, I guess the other thing I would say is that even assuming this was a private lot that was owned by Kohl's, I still don't think the store manager is entitled to just have the car taken away right there on the spot. Chapter 266, Section 120D governs the removal of vehicles from private property, and it requires written notice to the police to request that the vehicle be removed.
You know, it's probably kind of tough for police to know who owns the lot if it's right outside the Kohl's store. It's not an unreasonable assumption that Kohl's might have control over it, even if it turns out to be wrong.
Well, Kohl's is not the only store that uses this parking lot.
I know,
It's
but
a
you
strip
often
mall,
have,
and there's no reason.
Tenants and, you know, but in any event, let's just assume that, you know, that argument isn't pivotal. What about the question of the police having any obligation whatsoever to allow a phone call to be made to see if an alternative arrangement can be made?
The police's obligation under the Constitution is to behave reasonably, and the behavior in this case is patently unreasonable. It's just not reasonable to immediately tow someone's car away to an impound lot where they're going to have to pay in excess of $100 to get it back, based on an arrest for a misdemeanor, a non-jailable misdemeanor. When the person is standing there saying, please don't tow my car away, I'm going to have my girlfriend come pick it up, or presumably he would just be released to come get it himself. I mean...
The girlfriend was the owner.
The girlfriend was the registered owner, yes. And I want to distinguish this case from Eddington, where it was not clear that either occupant of the car was authorized to drive it by the owner, and neither occupant could produce the registration to the vehicle. Here, there's no claim that Mr. Violet was not authorized by his girlfriend to drive this car, and the Commonwealth has never made that claim, and I think it's implicit in the judge's findings that she found he was so authorized.
Thank you, counsel.
And unless there are more questions, I'll let my brother take over.
Okay, thank you.
May it please the court, Christopher DeMeo for Mitchell Violet. Just picking up on the last issue of the authority of Mr. Strabella to order the impoundment. I don't believe there are any cases where this court has permitted the police to impound a car on private property where the police haven't actually been involved in causing the car to stop where it did because it was an OUI case or a reckless driving case or something of that sort. The rationale there is that the police sort of were involved in causing the problem, and ultimately the person is going to want the car removed from their private property anyway, so just to expedite things.
Does the fact that the officer testified technically this is a public way, does that change the view about whether there's a private property or not? Or do you think it,
Well, I think
that's apples and oranges?
I think it just makes the government's case that much weaker. I mean, this is a warrantless search. They have the burden of proof. They have the burden of establishing that he had the authority. And granted, what Justice Lang said, it could be hard. There could be some ambiguity, but they just didn't do it. I mean, they had the opportunity on cross-examination to bring out, so is this Kohl's lot as opposed to the mall's lot? Do you have authority? He could have said that. It could have all been cleared up in a page or so. They didn't meet that burden. But I would argue it's sort of a red herring because the car was already there. This is a case where it's just happenstance it was parked there.
But suppose, so much seems to be on the reasonableness scale, seems to be with the fact is we're talking about a shoplifting. It's a misdemeanor. Not going to go to jail for this. Suppose, though, in the course of events, it was a much more serious crime. Suppose he was picked up for, exposing himself to a child or something inside the store. And police came and arrested him. And that could be a felony charge, an arrestable offense, one for which he could be incarcerated. Does the gravity of the crime make any difference to the reasonableness of the police behavior?
I don't think it makes a great difference, Your Honor. It's the fact that he was likely to be discharged from the police station in relatively short order is a factor, but impoundment, the main factors are, is it a danger to the car itself from theft or vandalism? Is it a danger to the public because it's blocking a public way? Those are the main factors, and I don't know that they would be altered that much because of the seriousness of the crime.
So the car could just be left there for months?
To correct to amplify what I just said, if it were a violent crime, that might make it more likely that, say, there's something dangerous about the car. But could it be left there for months? Well, yes. I mean, if the car is already there and it's not posing a threat, I mean, it could at some point become a nuisance, I suppose. I don't know what the procedure is for abandoned cars, but there's nothing in the nature of a felony that would make that would implicate those two interests on the danger to the car. And
had they gotten back to the car and were they in the car at the time that the police apprehended them? Or asked them
I don't know that it's entirely clear. It seems that they were leaving the store when they were stopped by the loss control people and brought back into the store.
Just on Justice Lang's question and what you said were the two factors, I mean, it would seem to me as a practical matter that it's relevant whether there is at least, whether the police have to follow it or not, but at least there is a suggestion of some disposition of this car. And that seems to me to be relevant, because if you were somewhere and it's a serious crime, let's just say, and there's no indication there's anybody else that's going to connect to that car, that's a very different situation than the one you've got.
Certainly, I agree, Your Honor. And this is not that case. This is a case where the car was already parked there, and Mr. Violet made the suggestion that his girlfriend come get it. So I guess there's sort of I see it as a two-stage analysis. The first is, ought the police to be moving the car at all in the first place? Should there be any sort of seizure? And then if that's warranted, then do they have an obligation to comply with this request to have the other person come get the car? So we would submit that you never even get to the second question, because the first question, the answer is no. The car's parked in broad daylight in a mall parking lot, no evidence of high crime, no evidence of danger to the public. You leave it there. But if the court does reach the second issue, then I would submit that because the police are charged with acting reasonably during an impoundment decision, that acting reasonably, if nothing else, at least requires that they consider a request to have someone else take the car. And it may be dismissed in short order. If the girlfriend was 2 hours away, then they will have considered it and immediately dismissed it. But we don't know. Certainly if Mr. Violet's girlfriend was 5 or 10 minutes away, the police weren't doing her any favor going into the car and having it towed off, and probably not doing themselves any favor either, because if she could have come and got it quicker.
Let me just get back to the sequence of events. I want to make sure I understand it. They were walking out of the store with items they had taken, and somebody in the store called for the police. The police arrived and apprehended them outside the store. Is that right?
I believe that they were actually back in the loss control, well, several officers arrived at different times, but I believe that when the testifying officer arrived, they had been brought back to the loss control area in the
But by the loss control people.
Right.
Yeah, and they had items that they had taken and not paid for on their person at that time.
Correct.
But so there was no connection to the car as of up until that point in time.
There really wasn't any nexus to the car. That's why I said it's sort of happenstance that
Yeah.
there was a bag in the car that the police wanted to check that also wasn't stolen.
And that's the one that had they found out that one of the defendants had a receipt for that bag.
Exactly. But it's happenstance, really, that they could have taken the bus to the mall, or there's not really the close nexus. But I'd just like to say in my last few minutes, this is a case involving, it's a fairly serious burden on Fourth Amendment, Article 14 rights. They're opening up the car, going through all the compartments, going through all the containers in it. It's being done without a warrant, without probable cause. It's an exception to those requirements. And to make sure that the exception doesn't swallow the rule, it's appropriate for the police, if nothing else, to at least consider reasonable alternatives that are suggested.
Thank you very much, counsel.